Hi, this is Zane, and welcome to another edition of the Trustcast Show. And we're really happy to have with us today Erik Heninger. Welcome to the show, Erik.
Hey, Zane, thank you for having me. Looking forward to talking to you.
So, Erik grew up hearing his father's courtroom stories at the family dinner table, and decades later, they've each won Alabama's Lawyer of the Year award. A rare father-son streak in a medical malpractice law, probably in any type law. Erik, what was it like sitting at the table around the dining room table, and how'd you end up deciding, well, this is exactly what I want to do as well?
That's an interesting question, and it's a kind of a winding story type of answer. But what was it like sitting at that table? It was intimidating because I would hear stories about usually horrible things that have happened to people, and different techniques or strategies that he's trying to use to help them and compensate them for what they've been through. Um, it was intimidating because I'm in high school watching this and college, and I guess those all my schooling, and just realizing that he was up and out of the house well before I even woke up. And then he comes home from the office almost time for dinner, and I'm about getting ready to go to bed. I'm thinking, this guy, all he does is work. And it was true. And it's hard work. You're talking to people all the time, is in trial a lot, reading a lot, writing a lot. That just did not sound attractive to me at all. Uh, Surely there's an easier way to make a living. And even now that I'm 53, I think there are easier ways to make a living, but I'm not so sure that there aren't more fulfilling ways to make a living. So, I went to college at a small school here in Birmingham, with plans of being an English teacher. So, think back, I didn't want to speak in front of people or write, that's why I chose to be an English professor. That doesn't make any sense. I did that for a little bit and realized this is not going to, meet my financial, uh, not obligations, but my financial future was a little uncertain. So I thought, well, what does a good English philosophy major do? Well, they go to law school. What else are we going to do? So I did, and really fortunate. Something clicked there, and I loved it. Just fell in love with the law. And, he gave me an opportunity to come work with him, and it's been successful ever since. I'm not going to lie and say that it's been, you know, rosy past the entire time, but we've made it work, and it's been a great partnership, and hopefully we've got many more years together.
So, now you're more than 2 decades into the business. Was there one early case that kind of cemented this into your mind? This is really what I want to do. This is my calling.
It probably happened before I even started in practice. So during law school, I would come over to the office and help out do different things, and part of my job being on the lowest rung of the totem pole was I would run errands for the lawyers. And I remember there was a really significant case that involved, it was on the interstate here in Alabama, and somebody was pulling something in a trailer, and it was a commercial vehicle, and the hitch unhooked, and it ran into the people that were traveling behind it. And when I say catastrophic, that doesn't begin to explain the severity of the injuries. And so I had known, just by being in the house and working a little bit at the firm, how big of an effort it was to get these folks compensated. And I remember, with some of the money that the firm recovered on behalf of the clients, he separated a pretty big chunk of that money and asked me to take it to the law school to create a chair for trial advocacy. And I was just thinking on my way over there carrying this check, and I still don't know how much it was. I know it wasn't $10, but the impact of all of his hard work, for the family, for the firm, for the community, because it changed a few things about the way people are allowed to operate vehicles on public roads in Alabama. And then what a gift it was to the law school. It touched so many different people and areas. I thought, wow, this is something that I would really enjoy doing. And I've said it many times that, there are not a ton of cases that have that impact on so many people. There are a lot of smaller cases that are really, really important to those clients, but every now and then you get an opportunity to be in a case like that. And I've been very fortunate. There have been about five in my career, and it just fills you up so much to know that you're able to do those types of things for those people and doing good things for the community, that doesn't happen again. So those would be examples. That case was probably the first one where a light bulb went off in me, thinking this is something that I would really like to do and get involved here.
So a lot of the smaller cases sometimes can be just as rewarding, if not more rewarding, if you kind of touch somebody in their family and what happens. Can you relate one of the smaller cases that kind of touched you in a way?
Absolutely. We all talk about I mean, trial lawyers think that everybody needs to hear about these big, huge verdicts. I mean, that's why you come hire us because we're gonna turn your whiplash case into a $10 million settlement. And it doesn't happen. So I hate to pop anybody's bubble. Those aren't real. But there are several, and one that I just finished for a client involves some sexual abuse, and in that particular case, there really wasn't any money changing hands, but it was an apology. It was a recognition of this particular business that what they had done was wrong, that they were negligent in the way that they handled certain things in the business and how they dealt with clients and customers that would come in. And just the apology and the changing in policies is what allowed that client to have some peace, knowing, okay, you know, it's unlikely that I'm going to receive any money just for a bunch of legal reasons, but being able to feel like they changed the way that this business ran, and hopefully it wouldn't happen to anybody else because this was a young female that was sexually abused in a massage parlor. A lot of insurance issues about whether there's going to be a payout at the end of that case. So literally no money changed hands, Zane. And that client keeps in touch with me. She is so thankful for what we did. Her parents are so thankful for what we did. They've referred several of their friends to our firm. So it's a case where no money was generated, but it had a huge impact on an individual and maybe even the community because they have now someone to contact and trust in us.
Hmm. That's great. So I'm going to pose just some hypothetical. So if I just got hit by a semi truck, what's the very first thing that I need to do?
I think it's funny that you asked that question because, I think it's so common that the first blog that every trial lawyer firm writes is the first 5 things to do after you've been in a car wreck. It's just kind of funny to me. But the first thing you should do is, contact the police. You need somebody to come investigate or at least document the crash. Take care of yourself first. If you need to go see a doctor, go see a doctor. The lawyer can wait, although I think it needs to be pretty high on your list. And the reason why you need to do that is if there are injuries, you really do need to take care of yourself. You got plenty of time to get a lawyer, but make sure that you're okay. Go to the emergency room, get checked out. Far too often, we see someone that's been in a wreck, whether it's a commercial vehicle or a passenger vehicle, the adrenaline kicks in and they think they're fine. And so they wave off the ambulance. I don't want to deal with the ambulance bill. I'm just gonna go home and I'll wait a couple of days. Well, if anybody's like me, the last thing I want to do ever is go to the doctor. And so I will come up with every reason in the book not to go. I've got a meeting today. You know, it's going to be better tomorrow. And what ends up happening is you have this lack of treatment and you may have serious injury. So just go get checked out. But then you do need to contact a lawyer for no other reason to make sure you understand what's available to you. And hopefully you get someone that's not going to promise you the moon and not going it's going to be very frank with you and give you the positives and the negatives about a potential case. It's going to be honest about the time it's going to take, the fee that they're going to charge, those types of things. And understand, just because you talk to one lawyer doesn't mean you can't go talk to another lawyer. And make sure that the person you're talking to, you feel a sense of trust. It has to be earned. You're not going to trust that person right away. But if you feel like they're being honest with you, and they're not promising you the moon, I think it's somebody you need to chat with. Just to put a fine pin on the commercial vehicle too, Zane, one of the things that drives me crazy in those cases is people do wait to contact a lawyer and usually for the right reasons. But people need to understand the insurance company that insures that truck, they've got a team out there that night preparing to defend the case that you're going to bring, which means they are already planning on paying you as little money as possible. So you need someone there to protect your rights and do the investigation on your behalf, make sure things are preserved for your case, just like the insurance company is doing for that trucking company.
So, when the other insurance company contacts you, and they obviously always want to settle
Sure.
right away, Is it ever, um, do they ever come up with their best offer and the first time they give you an offer? I mean, does the insurance company come in and say, okay, well, this happened, you're here, you're there, we're going to make you this offer, and it really is their best offer?
No, never. I think if I were in a trucking accident and I was the victim of a pretty serious injury, I know all the rules. I know what my rights are. I know how I can get the most compensation possible. They wouldn't give me the best offer. And so they are always, 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 and I'm highlight, bolden, put it in italicized, always trying to save money. And so, you start the question when the insurance company calls you. I tell everybody, don't talk to the insurance company because those conversations are recorded, and never are the questions posed or framed in a way that's going to help you. And so you can talk to him at some point when you have a lawyer and he can help you answer those questions appropriately. He can keep you from saying things that end up hurting your case. When I say that, I don't mean that they're going to tell you how to answer the question. Never do that. But they're not going to let you answer questions in a way that puts you in a bad light, and which is what the goal of the insurance company is to do when they make those calls shortly after the wreck. Maybe you're in the hospital and they call you, and it's just never a good thing. So talk to a lawyer before you talk to the insurance company. If you have to
So,
talk to them, real quick, if you have to talk to them, get a claim number and the name of the adjuster so that speeds up the process once you have a lawyer in place.
so if what about your own insurance company? I've heard that there's some risk in even talking to your own insurance company about.
I think they're the same risk, but it's a little bit different, and people need to keep this in mind. And so when this comes into play, let's say you're in that commercial vehicle wreck and you are one of the individuals that has tried to be smart and has what's called underinsured motorist coverage, or underinsured motorist coverage. That means if someone hits you and they have just a small policy of $25,000 and you end up having medical bills of 100,000, your insurance company will come in and help support or pay money to help you get back to where you were and make you whole. There are almost always provisions in your own insurance policy when we're talking about or UIM, which says you have to cooperate and sit for an examination or answer questions of your own insurance company. So let's say that happens to you and your insurance company calls you and say, hey, Zane, we want to talk about this wreck. I think you have a couple options. One, you can say no, which is bad. Don't do that. You can say yes, but not right now. Or you can talk to them. I would say yes, but not right now. I'm still not recovered. I'm still getting medical treatment. I'm talking to a lawyer. That's fine because the insurance company will wait for you to get a lawyer in place, and then they can have that conversation with you. They're not rushing you. If you just say, no, I'm not going to talk to you, they can deny coverage on your own policies. So you need to cooperate with them a little bit. But again, this is one of those occasions where if you get a lawyer, they can help walk you through that process, sit with you when you're having that conversation, and once again, make sure you're not answering questions that are going to put you in a bad light.
That's a really good answer there. Yes, but not right now. I think I've talked to a lot of lawyers and I haven't really heard that that spoken before. I'm sure that it is a philosophy of a lot of lawyers, but I hadn't really heard it expressed in that way. So I've heard that in Alabama, if I'm even 1% at fault, Eric, that I don't get jack. Is that true?
That is technically the way the law is written. And um, I've talked to many people about this. It's very easy for insurance companies to find a reason that somebody is contributing to their own injury. In fact, I had a client several years ago that was sitting still at a red light, an older lady. God, I was going to say in her 50s. I'm in my 50s. So a young, youthful looking lady. But she was literally sitting at the stoplight, stopped 10 and 2. Who does 10 and 2 anymore? And she got hit from behind by a person going, I think like 55 or 60 miles an hour. The insurance company denied that case because the adjuster looked at the law in Alabama and thought, okay, just 1%. Well, you contributed by the accident by being out there that day. So wait, let me get this straight. She contributed to this wreck because she left home? Yeah. So we're going to deny the claim. Like, okay, well, you made my decision very easy. You just went ahead and filed a lawsuit. We got a lawyer involved. So, and then we ended up settling the case, which is we should have. But yeah, that's the law. But I think people need to understand, and I wish adjusters were listening to this, that's never how it's applied in a case. Because if they want to play that game, you end up going in front of a jury of 12 people that are your peers in the community. And if an insurance company wants to say that you're sitting still at a light, but somehow you're responsible for getting hit from behind, they're going to light that insurance company up. That's just silly. That's just stupid. Um, and we have things where maybe somebody's going 57 miles an hour in a 55-mile-an-hour zone. I've had insurance companies say, no, you're speeding, so you can't recover. Again, ridiculous. So we have to go to court. And once we get a lawyer involved that understands the law and how it's applied in Alabama, they always say they don't understand the law. We need to talk about resolving this case. So it's confusing. It gives them a very easy way to deny a case here in Alabama, but we deal with it and get over it pretty quickly.
So how do you prove that, like in this instance, the example I use, a truck driver, how do you prove that they're at fault when you're in a situation where it's their word versus my word, and it's kind of, uh, it's not really clear cut?
Sometimes it can be difficult. There are a lot of different cases where you find that situation. The one you mentioned, Zane, about a car wreck, 9 times out of 10, when a police officer comes upon a scene, it's pretty easy for him or her to decide what happened or figure out what happened. Now, the wreck report is never evidence because the police officer obviously didn't see the wreck, usually didn't see the wreck. And so he's just interpreting the scene. And if it looks like the tractor trailer hit somebody from behind, okay, well, we can kind of figure that out. Why are you following so close? Or you wouldn't have hit them but for following them too closely. So, but a better answer to your question is, in the past 5 or 10 years, technology has exploded. And so a lot of trucks now have in-cab cameras that focus on what's in front of them, and sometimes even shoot back to watch the driver actually driving the car. Many people now, I've found, have videos in their own vehicles, in their passenger vehicles, just for situations like this when they occur. We've also got black boxes in most cars now that can detail how fast the individual's going or the braking speed, things of that nature. We've got apps on our phones which tell us, if my son's driving his car, is he going too fast, or is he driving reckless, braking too hard, things of that nature. And the same things apply to tractor trailers. So if it is a he said, or he said, she said type situation, now there's so much technology out there. We can pretty well prove just based on the technology. And again, that happens really rarely now. You have witnesses, technology, and then just the way that the wreck scene looks, you could pretty much piece together what happened.
How do you figure out how much my case is worth? So I'm in an accident. I mean, at what point, I don't know how you end up coming to a number.
That is the $1 million question. I probably answer this one 5 times a day. So a lot of it is experience, and I'm gonna go ahead and try and remove what I see often now. It is not. So if I'm in Alabama, it is not what a case resolved for in California. It is not what a case resolved for in New York. What we do as lawyers is say, okay, first of all, what is my case about? How serious is the negligence, or how serious is the wantonness? How bad is the conduct that caused the incident? How significant are the damages? Surely folks understand that a whiplash or neck strain case is going to be worth less than paraplegic case. So how severe are the injuries? How much is available in insurance? Just because you get hit doesn't mean that there's going to be $1 million in coverage. Here in Alabama, the mandatory minimum amount of insurance is $25,000. I've had a lot of cases where people have $300,000-$400,000 in medical bills, and there's only $25,000 available in insurance. So the conduct, severity of injuries, how much money is available, who is the defendant? Is it a hospital? Is it a commercial carrier? Is it just a passenger vehicle? And then where is the case brought? There are different pockets in Alabama where a case may be identical to another one, but it's worth more or less depending on what venue it is. What venue, I mean, are you in Jefferson County versus Mobile County, or Madison County up in Huntsville, or Fulton County over in Atlanta, Georgia, or Jackson, Mississippi? All these places are different because you're Your jury is made up of different people. Maybe they're conservative, maybe they're progressive or liberal, maybe they see injuries differently than another community does. So that's a big factor that a lot of people don't understand, and it's really hard to explain. But that's really just an experience piece of knowing what's going on in your particular state or region. So that's a hard question. It's not arbitrary. Sometimes we just kind of pull numbers out of the air when we're trying to negotiate. But
Mhm.
when you really get down to what the value of the case is, those are the factors that go into it primarily.
Okay, so let me try some rapid fire, just fun questions here in the middle. So soccer dad or volleyball dad, which sideline do you spend more weekends on?
Historically, it's been soccer, but now my son is moving into college, and my daughter has hit that high school and club team segment of her life. So it's definitely going to be volleyball for the next 4 years.
What's on your desk that has nothing to do with the law?
A good question. Uh, Nothing. Isn't that interesting?
Okay.
I need to get some more stuff on my desk.
Probably not. I've heard that a clean desk is a sign of a what well, I'm not sure whether it's an organized person or someone who's disturbed.
Well, I say it's disturbed because my desk is never clean.
Okay, so depositions or closing arguments, which do you enjoy more?
Closing arguments enjoy more. Depositions are far more critical.
Are far more critical
Hmm. For the success of a case. That is where cases are won and lost.
in the deposition. Do you use jury consultants?
We used to, not as much anymore. We've kind of developed our own AI program that will help do focus groups, and we can change information on the fly, and it gives us a lot of robust information depending on the venue that we're in.
No, interesting. Is that an outside program or something you guys developed there?
It's an outside program that um, it's private, so it's not available on the market. But another lawyer that we work with outside this firm started developing it, and so we tweaked it for Alabama and for what we see in our cases most commonly, and we use the information that's available to us in Alabama. So this other lawyer that started creating it was from another state.
Interesting. So one word, what makes a great trial lawyer?
Authenticity.
Okay. So you and Jay Stewart secured a $110 million settlement, the largest personal injury recovery in Alabama history. So Eric, what was that case like behind the scenes?
Um, just a horribly tragic case. In fact, I mean, it's one of those where we talk about what makes what do you drive, what drives case value. This was a case in which several young girls were killed, and just an incredibly tragic and horrific wreck on one of our interstates. It was a ton of work behind the scenes. There were many lawyers involved, several different law firms involved, just really kind of figuring out the technology because at that time we were seeing some things that were pretty new on the scene. And it was a knife fight in the phone booth getting some of this information, some of this evidence to help that case. It was it was really a challenge. It was really fulfilling, the final result. But it was a battle on the other side because there was that money available. And so what I find is when there's a lot of money available, that's when people get really, really tight and they want to argue about, the color of the sky, trying to save a few bucks. So that's a lot of what that case was about.
So when you have, you said a lot of money available because it does come down to usually how much insurance they have. Was this did you have to go after somebody's assets or a company's assets?
The case is still going on some small pieces. We have not had to go after assets yet. That's been a threat. It was something that we had to look hard at because uh, there are some insurance layers that were being withheld from us that weren't being disclosed appropriately. And so that threat that was out there about we would have to come in and take some assets really kind of loosened everything up. So, well, if that's true, then we might as well go ahead and disclose the other insurance that's available. So, it's not something that I like to do
Right.
because I don't like putting people out of business. I don't like taking people's homes. In fact, I can tell you right now, after 25 years, I've never had to do that. And I hope I never do. but it is something that you have to speak with your client about, and potentially the defense lawyer, and say, this is where we see this going if we can't cooperate.
So here's another one. You settled a California trucking case for $500,000 after two 18-wheelers collided. What made that case so complicated?
What made that case so complicated is it was not a high-speed collision. So oftentimes what adjusters, defense lawyers, or insurance companies do is they'll look at the result of the collision, and just looking at the two trucks, you could see damage, but you would never think that this collision or that amount of damage translated into an injury as severe as we had. And when I say as severe as we had a herniated disc that required surgery. This is a healthy young male in his, I think it was in the late 20s, early 30s. No reason he should be having neck surgery, but he did. And so that was a challenge. Just showing these folks or explaining to the insurance company, they already know. They do enough of these cases, they know that it can happen, but can we prove it in this case is what they're looking for. And so that was the challenge. The property damage just looked like it was, a winky dink kind of wreck. And it was more severe than they wanted it to be.
So this one is kind of interesting. You won a $1.5 million judgment against a cheerleading coach who was secretly recording minors. How does that kind of case even come to light so that somebody found out that, hell, this is even going on?
This was a crazy case. The client found out about being recorded. This was maybe 8, 9, 10 years later,
Wow.
because the defendant, and ultimately the criminal defendant who has now been sentenced to prison, was caught carrying these tapes or, photographs on a laptop. He was trying to go to a foreign country where he would have a contact and they would disseminate it on the black web. And so they found him. They opened up his laptop, found all this stuff, and through efforts of the FBI, were able to identify the victims. So the FBI had to contact the victim and say, hey, look, we found your picture, and we found your picture in this circumstance. So met with the mother and the daughter that was in the photographs, and they were devastated and never thought anything about this. I see it time and time again in these sexual abuse types of cases that the victims may or may not know. There, in this particular case, a camera was hidden in a clock in a room that he encouraged the girls to go change into before cheerleading practice. And in another instance, there was, I'm talking young, I'm talking like 5, 6-year-old girl at a cheer camp that was changing in the bathroom of this cheerleading coach's hotel room. And he had set up a camera there and recorded her in the bathtub at 5 years old. And so, unfortunately, in that situation, he didn't have any insurance. There was not going to be insurance that was going to cover that. He had no personal assets. So the $1.5 million judgment is a default judgment that was entered by the judge because he wouldn't go to hell. He was in prison. And so if for some reason he ever comes into any money, maybe he writes a book, I don't know what's going to happen, but we have that judgment out there that we can go after any assets he may obtain. I just don't see him getting out of prison anyway, though. So it's more of a pound of flesh type of situation.
Yep.
And again, a situation, no money changed hands, but the clients are tremendously thankful and happy that they were able to do something on the civil side to protect their rights and interests. And another difficult aspect of that is they had to go out and testify in a criminal trial in Texas for sentencing hearing. Really, really brave young women, very proud of them, but that was a tough situation.
Wow. So they actually had to travel to testify against the individual involved in the.
Yep.
And so when in those cases where you don't really, you in your type of practice, it's mostly, it's rare when it's not on contingency. So when there's nothing recovered, do you just consider that a community service that you're doing?
Yeah, that was a wash. I think we knew going in when I was talking to the family, I said, look, the likelihood that we're going to recover money is next to nothing. And I want y'all to know that going in. And they understood it. We understood it. We felt like it was a good community service. Holding these types of individuals accountable is really, really important. if for nothing else, I can go and tell the story to a group of other cheer moms and cheerleaders, say these are the types of things you need to watch out for. And by having that case, we're able to talk to people about these are the circumstances where you need to protect yourself. And people who are considering doing these types of things say that there are at least from his standpoint, criminal issues and civil issues if you do it. So maybe it prohibits or prevents some conduct.
Hopefully. So your firm has recovered, okay, this is kind of eye-popping, Eric, more than $3 billion for clients. What does a number that size actually represent to you?
It represents a lot of hard work and longevity, and a lot of good employees, and a lot of good lawyers, and a lot of hard work. So keep in mind, when I mentioned what I did, we also have another group in our firm that does work called mass torts. So there may be a pharmaceutical medication out there that consistently harms people in a certain way. And for example, there may be Roundup's one right now. It causes Parkinson's. We just discovered that. So that's a mass tort. So we can represent individuals in that cases across the country. And those are large settlements. Now, we're not claiming the 3 billion as part of the overall settlement. It's just what we've been able to cover for our clients. But we've been involved in some pretty substantial settlements on the mass tort field as well. So that's I don't want people to give anyone the impression that we're getting $3 billion in medical malpractice. That would be inaccurate. But total recover for the clients over a 25 year period is 3 billion. It's probably more now. That was an old number.
So, I'd like to get into the Roundup thing, but I feel like I could talk to you for at long time on that one. So, because I think it's just an interesting subject in and of itself. So you've been named. So I'm going to skip over that. You've been named Medical Malpractice Lawyer of the Year 3 times: 2022, 2024, and 2026. What kind of case tends to win that sort of recognition?
Well, that's a very good question. I think that was a vote by our peers in the community that handle medical malpractice from the defense side and from the plaintiff side. So it's a huge honor. But I think we've got to be really selective about the cases that we take because they are so risky and they are so expensive. And in my community here in Birmingham, the largest employer is a health system. And so when I go to trial, if I get 40 people to come down for a venire where you pick the jury from, 30 of them are going to be associated with the medical field in some capacity. So that you've got to be very careful because people are protective of that industry here. But if you go back to the questions you asked me about, how do we value cases? It's the same value or same metric that we go through in picking the medical malpractice cases. I mean, is the conduct really bad? Unfortunately, when we go to hospitals, there's always the chance that there's going to be a bad outcome. We're sick, something's wrong with us already when we go there, assuming, we don't usually go there when we're healthy. And so that puts us in a situation where bad things can happen, even in the absence of negligence. So we got to figure out how significant is the conduct that we're claiming caused the injury. There are ways that we do it, and we sometimes get experts involved. But over 20 years, we pretty much figured out what type of case we want to handle, and what kind of case we don't want to handle, or we don't need to be handling. So again, how bad is the conduct? Are we suing a surgeon where judgment call is involved? I hope not. That's a difficult case. Is it a nurse? Is it a medication error? Do they give, 10 times the amount of Dilaudid that they should have given, and that kills somebody like this? That's a good case. It's a sad case, but that's a good case from a legal perspective. And then how significant are the injuries? So, being careful about what we take and knowing what this community finds offensive as far as medical care, and then whether we have the bandwidth to take on that medical malpractice case are all decisions that go into it. So I can't really get into specifics of the really bad cases. There's some that are going on right now that I probably shouldn't talk about either. But, it goes back to the cases that are really significant where you change the way medicine is practiced, at least in Jefferson County or in Birmingham. We're at that hospital. And we've had a few of those here recently. And I guess maybe that's fresh on some people's mind when they vote. But again, tough cases, tough law. Those are really, really, really hard cases to win in this venue.
So if I'm talking to surgeons and doctors, they get all pissy and angry that we have to practice this defensive medicine,
Yeah.
but I guess they don't like all the documentation. They don't like all the charting. But I guess when you balance things out, somebody gets hurt.
Yeah. Yeah. I don't like it either. I'm just as much at risk as they are. I mean, I've got to go see doctors in this community. So I want to keep them. I want to keep the good doctors practicing medicine. And lawyers like myself, we can probably figure out who the good doctors are. You'd be amazed at how often I see the same doctor's name come across my desk time and time and time again. And there are some consistent patterns we see with maybe a medication or a communication issue. Those things happen recurrently. And you're right. When you hit on the documentation, they hate it. The nurses hate it, but it is absolutely necessary because what the doctor needs coming after them is to understand what happened. What were the signs and symptoms of this disease here, and how have we progressed 6 months later? Are we getting worse? Are we getting better? And if they're practicing medicine in a way that they don't want to document, that creates another opportunity for harm for this patient. So I think if we can, I know it's Pollyannish to say, can we all be honest and do our job appropriately? It's not going to happen. Otherwise, I wouldn't have a job. But gosh, just doing the right thing should be pretty simple.
So is there a single case during your career that really kind of sticks with you?
There are several. I'll give you two, um, and they've been resolved in a confidential nature, so I've got to be careful about what I say. Um, One that really sticks out to me is a first sexual abuse case I took in my career, and it was probably 10 years ago. Affected a number of boys at a church here in Alabama that were being sexually abused by a youth minister. And it was just, I cannot imagine a more tragic case. I go to church frequently. I've got kids that are that age of these boys that were abused. It was a hard fought case. And again, another tragic case, but the end was worth all the work. But seeing the impact on those boys' lives then and knowing where they are now, still having significant mental health issues because of that abuse, that really sticks in my mind. So again, that's one of those cases where I feel like I did a good job, or we did a good job and got a good result. And I'm going to flip it and give a bad result, and it kind of keeps things fresh in your mind about what you got to be thinking of as a trial lawyer. We had a case where person was in surgery and it was an open heart surgery, and they had to use a tube to, fix where their vision was going to be so they can just operate on that little area. And it required them to hammer it in to get it in the right place. Well, before you start hammering, you're going to make sure that all the vessels are out of the way so you don't cut a vessel and the guy bleeds out. Well, they didn't. And they did cut a vessel, and the guy did bleed out. No question that there was negligence or malpractice occurred in that case. In fact, the two doctors in the surgery were pointing fingers at each other, saying, no, he did it. Well, he should have done this. Well, he should have done that. They did the same thing at trial, Zane. And so I'm thinking, after closing arguments, I'm sitting back and we're thinking, we just have to watch now. What are they going to do? We're going to win, but what are they going to do? Well, good lesson for a trial lawyer, and I was young then, is never assume anything. The jury got so confused with who to hold responsible, they held in favor of the defendants that no malpractice was committed because they couldn't figure it out. And so that was a hard walk back to the car with my clients when we had all the evidence available to us, but the jury just said, we don't understand. We can't figure out who was at fault. So nobody's at fault. And so two very different cases on the spectrum, but two very good lessons for me to remember as I go through my career.
So if you had that to do over again, would there be some change that you would do in the closing arguments or just in the conduct of the trial to establish, hey, if you go this direction? I'm sure that now you looking back, you think I would have done this. I'm just kind of curious your brain now thinking about the whole.
Oh, yeah, you what if yourself to death and do it now. And sometimes it's a detriment because we talk to jurors after a case and they say, God, can you stop repeating that over and over again? And I want to say, I will. And I give them that story. I said, look, they didn't understand it. Maybe if I had talked about joint and several liability one more time, they would have figured it out. There's no assurance that they would have, but of course. So it's a balance. But would I have done things differently? Absolutely. Knowing what I know now, I I would have hammered that home. That would have been the only issue that I addressed in closing argument. But you don't know in real time. It could have been that they didn't like the color of my suit, Zane, and they didn't like me or my last name, or they don't like lawyers that are losing their hair. Juries are fickle, and so you don't ever know what they're thinking. It's a gamble every time.
So, what's what's different about handling a case across state lines, Alabama, Georgia, Mississippi?
Well, I live in Alabama. I'm very familiar with the lawyers here. Have a good relationship, good rapport. I think the professionalism and civility in Alabama is still alive and well. I think when I cross state lines, I'm looked upon as an interloper, and I don't have the same relationships with those lawyers. So that automatically puts me in a position where I'm saying the professionalism and civility in this area is a lot different than where I come from. So it's different, making sure that the laws are followed, because there are differences amongst all three states. And I can go north and south, Tennessee and Florida. It's going to be different than anything else as well. So first thing, you got to be careful. And you have to assume that you're going to be, looked down upon because you're coming into a state that has its own lawyers, or why are you coming in here and trying to practice these cases? But I find time and time again, if we get past that first phone call, that first meeting, if I'm professional, if I'm civil, if I'm humble, and I'm authentic with the other lawyers, we can usually get on a path where we are cooperative with one another. But if you go in there like Rambo and start making threats and being a turd, it'll never work out well. And so those are the primary things.
So, what's the biggest misconception, Eric, that people have about personal injury attorneys?
Oh, I'm gonna say, I'm gonna give you a couple things. One, there's an assumption that trial lawyers like to argue, and I don't think that's true. In fact, we don't get to argue very often in front of a court. It happens maybe 5% of the time. Agreement is far more beneficial to the client. And so getting to a point where we can agree on certain things is really the goal. So I hate it when people say she loves to argue, so she's going to be a great lawyer. Well, yeah, maybe a great defense lawyer. Um, but I also do believe, and this may be again Pollyannish, because I know that there are going to be examples that we can point to after I say it, that trial lawyers are greedy. Um, I don't think that's true. Now, again, I can point you to several names, even in my city, where I think that is an incorrect statement, that I think are greedy. But on by and large, we really do care about the clients. We really are trying to do the right thing. And by greedy, if you say, am I trying to get the most money I can from my clients? If that's your definition of greedy, then yeah, I'm greedy. I'm going to try and get them everything that they deserve. But if you think that I'm going to screw over my clients, or I'm going to screw over my partners or lawyers in my firm, or referring lawyers or people that I work with to get more money, that could not be further from the truth. And so I hope people understand that we're in the same boat with our clients. Everything that we do is to help them. And I'm hopeful that, at some point people will realize that. It's unlikely, because we get painted with a broad brush by insurance companies, but we don't like to argue, and we're really not that greedy.
Okay, so do people wait too long to call you after an accident or a bad medical outcome? And does that hurt their case?
Yes and yes. So people do wait too long. It hurts their case in the sense that at at the point that they do call us, usually the evidence is gone. So the best situation is if a individual's in a wreck, or an individual has a bad outcome, whether it's slip and fall, or sexual abuse or medical malpractice. Call me and let me decide whether I need to go to the scene and take photographs. Maybe there are skid marks at the scene still that are going to be important for this case. If you call me 6 months from now, those skid marks are gone. The scene could be different. It could be under construction now. Um, if it's a trip and fall, the store could have changed what they had out there. They could have changed the signs or changed the displays. Medical malpractice, records could be lost. Witnesses have forgotten. You would be amazed at how quickly doctors and nurses forget about conversations that happen in the patient's room. And why is that? Because they have a lot of patients, and those conversations aren't documented in the medical chart. So it really prevents us the opportunity from gathering the evidence that's going to be crucial to the case. And so the sooner you get with a lawyer, the sooner we can go out there and capture that evidence and think about what are the best ways to prove your case and get around issues that we can see coming up. But if we don't have an opportunity to get the evidence, it's going to be lost and it hurts you.
So I'm going to shift gears a little bit. What do you, as far as building your practice, where do you see the practice like a year or 5 years from now? Is it something where you're looking to maintain your size, or you're looking to grow the firm, or?
I think as an entrepreneur, I think most law firm owners have to be entrepreneurial. You're always thinking about growing the firm. But the challenges I see in the next 1 year or 5 years, trying to wrap our hands around technology is going to be a real challenge. And then how are we dealing with the influx of money through private equity and people funneling money into law firms and allowing them to go advertise or market or buy cases? It's a real challenge. And I think our bar association and our courts are moving towards answering those questions. But what's going on privately is happening so much faster than the court or our legislature or bar associations can keep up with. So, how is AI going to be implemented in law firms going forward? It's going to be a real challenge because we have a spectrum of lawyers, we have a spectrum of employees that can maybe as young as 19 and can be as old as 85 or 90 years old. That's a huge disparity in comfort of using technology. And, in order to grow, you have to have customers, just like any business, you have to have clients. And so you have to be out there developing relationships with other lawyers or developing relationships with people in the community that are going to send you business. Because if I just sit here, I may be the best trial lawyer in the world. But if nobody knows my name except the judge at the courthouse, guess what? I don't have any clients. And so getting out there and communicating with people is always a challenge, making sure that your relationships with referring lawyers or other associations, you've got to keep up that too. So, Zane, I have no answer for you because I really don't know where we're going to be in 5 years. I hope I'm still here in 5 years. I hope I'm not replaced by some robot, but I think anything's possible at this point.
So what is your best mechanism for getting new clients? I mean, aside from referrals are always great from either the community or other attorneys. Do you use a particular mechanism for advertising that one works better than the other? Or?
No, we've tried to do it organically. We have never been the type of firm that's been comfortable advertising. Um, when I started, we talked about my father. He grew up in a time where advertising was frowned upon. Good
Right.
lawyers shouldn't have to advertise. And that sentiment has changed dramatically over the past 20 years. Um, but I don't think now, from a very financial or economic standpoint, I can't go buy $10,000 worth of advertisement time and actually compete with some of the bigger dogs that are out there spending millions of dollars. And so the referral relationships that you mentioned, that's got to be strong. And organically through social media, being out, talking to people, being involved in your community is critically important. Being involved in charities, doing good work, and connecting with people. It's the old way that lawyers would get business. It still works if you do it in an authentic manner, and it means something to you.
So Eric, if somebody's listening to this and they're in Alabama or Mississippi or Georgia, and they say he sounds like a straight shooter, how do I get in touch with him?
Well, you can go to our website. It's hgdlawfirm.com, or you can email me, ERIK at hgdlawfirm.com. Our phone number is 205-326-3336. And we're all over the place in social media. So Instagram, Facebook, TikTok, I think we're there too.
Okay, great. Thanks for coming on the show. I really appreciate it.
Thanks, Zane. I enjoyed it.